All right, good morning, everyone. Welcome to the California Medical Board Panel A meeting. Today is Wednesday, August 19th, 2026, and call the meeting to order at 9:12 a.m. Can we please take the roll?
Yes. Mr. Arkartov,
Here.
Dr. Ayala Rodriguez,
Here.
Ms. Chung,
Yes.
Dr. Mahmood, Dr. Solis,
Here.
Dr. Sai,
Here.
Mr. Watkins.
Present.
We have a quorum.
Thank you very much. We'll go on to our first agenda item, oral argument on non-adopted proposal decision for Dr. Aho. Go ahead and proceed.
Okay.
Have
Hold on a second here.
because we're doing mixed video conferencing and in person, so if we can just have everybody introduce themselves so we know who the parties are. We'll begin with you, sir.
Good morning. My name is Christopher Aho.
And via video conferencing?
Yes. Good morning, everyone. Nicholas Jerkowitz, attorney for Dr. Aho.
Thank you. Next, do we have our DAG on? Oh, right here. Sorry. Thank you. And do we have our administrative law judge present?
Yes, I'm here, and good morning, everybody.
Thank you, Your Honor. Anyone else we need to introduce? Okay. All right, we'll go ahead and proceed. So the format, of course, that we'll have our administrative law judge presiding over. So I will hand over the floor to Your Honor.
Well, thank you very much. And again, good morning, everybody. So we're on the record in the matter of the petition for early termination of probation filed by Christopher James Aho, MD, OAH case number 2026-071-155, agency case number 800-2025-116580. Before we proceed, can we have our court reporter identify herself for the record?
Good morning. My name's Irene Lim, court reporter, CSR number 15187.
Good morning and thank you. Today is August 19th, 2026. It is 9:16 a.m. and this matter is proceeding in part by video conference before a panel of the Medical Board of California for the parties to make oral argument regarding the board's order of non-adoption of the proposed decision of the administrative law judge. My name is Abraham Levy. I'm an administrative law judge with the Office of Administrative Hearings, and I know the parties identified themselves earlier, but again, can I have the parties identify themselves and make their appearances?
I'll go first. Good morning, Your Honor. Nicholas Jerkowitz, attorney for Dr. Aho. And I'll note present in person is Dr. Aho.
Yeah, and I'll just note that I'm appearing as administrative law judge through the WebEx platform. The panel are appearing in person. And Ms. Smith, can you make your appearance, please?
Good morning, Your Honor, and members of the board. Rebecca Smith, Deputy Attorney General.
Good morning. As set forth in the notice of hearing and oral argument, both parties are limited to 15 minutes for initial arguments and 5 minutes each for closing statements. After the parties make their respective arguments, absent any questions panel members may have, the panel will go into executive session and decide the matter based on the existing evidence of record and the transcript of the matter, and will issue its decision in due course. With that, we'll start with petitioner, Mr. Jurgowitz.
Yes, thank you, Your Honor, and good morning to the panel. Let me start by saying that Dr. Aho is there present. He's here. And if anyone has any questions specifically for Dr. Aho, he's available and willing to answer any and all questions. I probably will also reserve some of my time here to allow Dr. Aho to address the panel directly. I want to start by saying thank you very much for the opportunity to be here. Both Dr. Aho and I recognize the importance that this panel and the medical board plays in, maintaining safety in the state of California. And both Dr. Aho takes that very seriously, as do I. And we didn't file this petition lightly. We weighed the factors and believed very strongly that Dr. Aho should have his probation terminated, and that remains to be the case. And hopefully I'll be able to explain to you sufficiently why that is. I want to start by saying something that I'll support as I continue arguing, and that is that Dr. Aho's case for terminating probation is about as good as any case you could imagine. I mean, if you were to write up a case to support the notion of terminating probation early, this case and the facts within this case are pretty much about as good as you can get. We are going back to 2019. So we've got documented sobriety of 7 years. And even though the medical board discipline wasn't implemented until approximately 3 years ago or so, we have documented evidence of sobriety dating back all the way to 2019. So you've got a duration of, closer to a decade than 5 years of documented sobriety, no relapses, no issues, no concerns, absolutely no evidence of anything to the contrary. I also want to highlight and point out that Dr. Aho did not make excuses. He did not deny. He did not gloss over his conduct. If you take a look at the judge's proposed decision and findings, particularly findings in paragraph 13, findings in 28, findings in 27, those are paragraphs, of course, you will see that the judge found Dr. Aho to be candid, heartfelt, and credible in his testimony. He admitted immediately in 2019, and this is a finding in paragraph 13, he admitted to Dr. Kristen, who was one of the witnesses, about what occurred. So immediately from the get-go, Dr. Aho sought to fix this situation, to cure himself of this, and accepted responsibility immediately in 2019 and continued to maintain and accept responsibility throughout, including during the hearing. And the judge recognized and understand that. And as I said, I'll give Dr. Aho a chance to address you directly, and I'm sure you will agree that he is heartfelt, candid, and credible in his testimony. If you look at paragraph in findings 28, and this is supported, of course, by the testimony, which goes into more detail, Dr. Aho today has remarried, and he has established a better relationship with his family. There was also testimony and recognized that prior to this, so we're talking about 2017, 2018, 2019, when Dr. Aho was having these issues, that was not the case. He was going through a bitter divorce. He was having, other stressors in his life. He's a different person now. His personal life is very different than it was then. That further supports rehabilitation. If we look at paragraph 28 of the findings, as Dr. Aho also testified to, he sleeps more, he has less stress in his life, He takes on fewer patients in providing patient care. He was taking on a lot of call and working a little too hard around the 2019 timeframe. So he's slowed down. All of that further and sufficiently supports rehabilitation. It supports that Dr. Aho is a different person today in so many ways than he was when this conduct occurred. I want to take a step back now from the evidence and just address a point that was raised by the medical board in their brief. And it seems to be, I'm going to summarize this in my own words, the medical board's argument, which is essentially that Dr. Aho's conduct initially was so egregious that he shouldn't be given a termination of probation. In essence, because of what he did in 2019, that's enough to make him have to go forward with full probation. I think that argument fails, and this panel should fully reject that argument for two reasons. Reason number one is the evidence doesn't support that. Quite on the contrary, there's absolutely no evidence in the record at all that supports in any way, shape, or form that Dr. Aho remains a threat to the public safety, that he remains a risk of repeated behavior. All of the evidence is to the contrary. The medical board presented no witnesses. They presented no documentary evidence that supported anything else. In contrast, we presented several witnesses and documentation that supported the opposite, that he's been in sobriety, he's been compliant with all terms of probation, he's been compliant in all his testing, which has all been negative for any substances. And with the 7 years that have elapsed, his witnesses, including Dr. O'Mahony, which I'll get to in a second, his prognosis is excellent for continued sobriety. The second reason why you should reject the medical board's position is that it essentially, and I shouldn't say medical board, but the attorney general's position in the brief, is that it essentially writes out the statutory provisions that allow for early termination of probation. If we focus solely on the conduct itself as a basis to deny early termination of probation, you're ignoring a statute that provides for early termination of probation when warranted. And so, this, as I said when I started, this case is as good as any. There's zero evidence to support anything here other than that he is rehabilitated, that he is safe to practice medicine without any restrictions at all. A few more points of the evidence that I'd like to raise before I turn this over to Dr. Aho. He's engaged in the program of flying knee with no relapse or issues for 7 years. That's in finding 15, paragraph 15. He was noted to be by Dr. O'Mahony to be the longest attending member of flying knee. He's an active participant and a leader in the group. And per Dr. Mahoney's testimony, his prognosis is excellent. That's finding 19. He's been in full compliance with his probation. That's in finding paragraph 20. Dr. Manassian, who proctored and monitored Dr. Aho at his hospital shortly after the August 19th incident, he said that since Dr. Aho's sobriety, he's been humble, accepting, he's been more balanced. That's finding 22. And also another point I think very important to raise is that in applying for a new job within the last year, Dr. Aho was very transparent with his prior substance abuse issues and the medical board issues. That's in finding 23. And one of our witnesses, as the board may know from reviewing the record, was the medical director of the group that Dr. Aho has recently been hired by. So he's been practicing medicine in the interim as well, with no relapses or issues in terms of clinical care. And so at this point, I'm going to give Dr. Aho an opportunity to address the panel, and I and Dr. Aho remain available for any and all questions. Thank you.
Good morning. I'm pleased to be here with you guys today. Okay.
Could we have Dr.
Yeah.
Be sworn in?
Yeah, I'll swear the doctor in. I was finding the unmute button here. Sorry for the delay, folks. It gets me every time. So, Doctor, I'm going to swear you in. Please raise your right hand. Do you solemnly swear or affirm under penalty of perjury the state of California that the testimony you give will be the truth, the whole truth, and nothing but the truth?
I do. I do.
And then again, just for the record, just state and spell your name for the record.
Christopher Aho, AHO.
You may proceed, sir.
So good morning. First, I just want to say I'm pleased to be here with you and given the opportunity to speak with you directly. It's important for me to come in person, just so you could get to know me and make a impression rather than just digitally. I'd also like to say that my actions in 2019, I'm just very ashamed and embarrassed. I never thought I was somebody that I would be pretty judgmental of someone who did that as well beforehand. And it ended up being me this time rather than somebody else that did some egregious acts. Since that time, I really did everything I can to person or set my life up in a way that would never happen again. I went to rehab.
Sorry. It got a little fuzzy. Could you say that last sentence one more time, please?
I was just saying that I did everything I could to improve myself and make sure that it never happened again. So I went to rehab. The biggest thing in my recovery is the AA program. So I've taken that to heart. I've done the 12 steps 2 times. I have a sponsor. I sponsored 2 other doctors in early sobriety. I was co-secretary of the Caduceus meeting in West LA for 3 years, where we kind of, if you don't know what Caduceus is, it's doctors in AA. I've also spent time teaching the USC medical students during their addiction series regarding physicians and substance abuse, in particular, what could happen to the medical students and where they can find help before it gets too severe or before they get in trouble. I did want help, previously to my incident, and I didn't really know a safe place to go or a safe person to tell, and I didn't. Maybe I guess it's not an excuse. It's just I had a lot of responsibility, and I wish I knew where to go, and so it's important to me to help other physicians in early sobriety or currently having trouble. I'm 7 years sober, August 1st, so documented sobriety. As my attorney said, I think really through the 12 steps, I'm on new ground. I think I'm a different person now. More humble and less judgmental and patient. I also appreciate the ability to keep practicing. So the medical board allowed me to do that and help me grow. I don't think well, I've done everything that was asked of me of probation, and I feel I went above and beyond that as best as possible.
Doctor, I'm just going to, I hate to break in here, but
Sure.
the oral arguments are limited to 15.
Sure.
Mr. Jerkowitz, we reserved time for you. We're at 9:32. We started at 9:17. And I sort of, please finish your thought.
You got it. So,
comments.
I'm open to any questions, and my life's transparent, and welcome me to do so.
Okay, with that, I know that Mr. Jerkowitz had mentioned inviting any questions from the panel members. Do any of the panel members have any questions for Dr. Aho?
Any questions from the panel? Okay, Dr. Ayala Rodriguez.
But sorry, are we doing the questions until we end like with both or right now?
Your Honor, do we want to entertain questions at the end of the presentation, or do we want to do it throughout the presentation?
You know, I think the best way to do this is to do it at the end and let the Attorney General present.
Sure. We'll
this-
follow your lead. We'll table all our questions till the end.
Okay, I appreciate that. Thank you. So with that, Ms. Smith, you may proceed.
Thank you, Your Honor. The administrative law judge in this case got it wrong. Petitioner is now 3.5 years into his 5-year probationary period. Oversight and supervision for the full 5 years is necessary to protect the public. The misconduct for which petitioner was disciplined was serious. By way of background, on January 25th, 2022, the board filed an accusation against petitioner, charging him with the inability to practice medicine safely without practice restrictions and gross negligence in his care and treatment of a patient. Specifically, petitioner performed an anterior cervical discectomy and fusion procedure on this patient while under the influence of alcohol and controlled substances, and then abandoned the patient without explanation. This impaired neurosurgeon was noted to have dozed off during the procedure. The same day of the surgery, the hospital asked him to undergo drug testing, and he refused. This is just one surgery which the board is aware of that petitioner performed while under the influence of alcohol and/or controlled substances. The hospital summarily suspended petitioner's privileges. Thereafter, petitioner completed an inpatient treatment program and aftercare program. He underwent mental and physical evaluations by medical board evaluators. He was assessed as suffering from psychiatric conditions, severe benzodiazepine use disorder, severe alcohol use disorder, all in early remission. The medical board evaluators opined that in order for him to safely practice medicine, he requires practice restrictions. Specifically, petitioner needs to continue with his participation in his aftercare program, including remaining under the care of an addiction psychiatrist and abstaining from addictive substances. And on September 9th, 2022, petitioner signed a stipulated settlement agreeing to discipline. The board adopted that stipulated settlement as its decision effective January 12th, 2023. The terms and conditions of the decision included a probationary period of 5 years, partial restriction on controlled substances, maintain records and access to records and inventories of controlled substances, abstain from the use of alcohol and controlled substances, educational coursework, prescribing practices, medical record keeping education or ethics courses, practice monitor, substance abusing licensee terms and conditions, including biological fluid testing, substance abuse support group meetings, and a worksite monitor, patient disclosure of probation, and all standard terms and conditions of probation. 2 years into this probation, January 20th, 2025, petitioner submitted his petition for early termination of probation. The administrative hearing on the petition was held on February 2nd, 2026. Petitioner has not demonstrated by clear and convincing evidence that he should be granted the privilege of early termination of probation. The evidence petitioner presented displays that he's merely in compliance with the terms and conditions of his probation, nothing more. Petitioner has not taken any coursework. He's not performed any community service. He's never bothered to contact the subject patient and apologize for his abandonment. And most importantly, he has not recently undergone an evaluation to assess his risk of relapsing into alcohol and/or substance abuse or any type of psychiatric evaluation. At the time petitioner entered into the stipulation to settle the accusation against him, he was in treatment with an addiction psychiatrist and a psychologist, as well as participating in support group meetings and biological fluid testing with Flying Knee Support Group. He terminated the treatment with both the psychological providers only after a year. He wasn't discharged from their care. He terminated it. Petitioner was granted a stipulated settlement because the medical board's evaluators opined that in order to practice medicine safely, petitioner needed very close monitoring and supervision. Those evaluators took into consideration that petitioner was in treatment with an addiction psychiatrist, a psychologist, and with Flying Knee Support Group. Petitioner only remains with Flying Knee Support Group because it's a condition of his probation. Dr. O'Mahony, the owner of Flying Knee, testified that she does not know if petitioner will continue to attend her group meetings if his petition for early termination of probation is granted. Petitioner engaged in serious abuse of alcohol and multiple substances for a prolonged period of time, and he continued not only to see patients but perform neurosurgery while under the influence. His staff privileges were suspended at PIH Health Hospital in 2024 while he is on probation, yet he seeks early termination of probation so he can obtain staff privileges at additional hospitals and increase his workload without providing a support plan. Petitioner testified that his safeguard is attending AA and working out a lot. He admits that he's either one step away from a drink or one step closer. And despite this candor, petitioner lacks insight into his continued recovery and sobriety. Petitioner testified that he's already working 40 hours a week. He only attends Flying Knee group sessions once a week and AA up to 3 times a week. He has no individualized therapy. At this time, early termination of probation would result in him working in excess of 40 hours a week. There's no guarantee he would find time to continue with Flying Knee or AA. And he certainly feels he's not in need of addiction therapy or psychological therapy of any sort. And this is a scenario for disaster. Given petitioner's serious misconduct and the severity of his substance use, a plan with respect to his future treatment, including group support meetings, must be in place prior to considering early termination of his probation. Potential public harm exists should petitioner's probation be terminated early. Petitioner also needs a plan to cope with an increased workload. He's now working the 40 hours a week and is in the early stages of establishing a new neurosurgical practice in Lancaster. Dr. Leiker, petitioner's worksite monitor and owner of the practice where petitioner works, testified that petitioner is taking baby steps to return to full practice, and hopefully he'll be granted privileges at additional hospitals and surgery centers. Once petitioner is on staff at different hospitals and other surgery centers, his workload will increase. He has not established a plan to cope with an increase in his workload, and he is either one step closer or one step farther away from using. Public protection necessitates an evaluation, medical clearance, and a plan to handle the stressors of an increased workload. Petitioner failed to provide sufficient evidence of rehabilitation. The fact that he has complied with the terms and conditions of probation as required and expected by the board is not sufficient justification to now assume that the public protection afforded by keeping petitioner on probation is no longer necessary. Other than complying with these terms and conditions of probation, petitioner has not presented evidence of a meaningful and sustained period of successful rehabilitation. And Dr. Aho should be commended for maintaining his sobriety, remarrying, establishing a better relationship with his family, being humble, more accepting, and more patient. Those are important self-improvement elements. However, it is your duty to protect the public. The specific terms and conditions of petitioner's probation insert ensures oversight of petitioner's neurosurgical practice that were specifically tailored to protect the public. To prematurely remove those safeguards and allow petitioner to practice neurosurgery unrestricted will place public health, safety, and welfare at risk. Petitioner has not met his burden, and it would be contrary to public protection to terminate his probation at this time. The proposed decision granting the petition should be non-adopted. Thank you.
Okay, well, thank you. So at this point, per the
Your Honor, you're on mute. Your Honor, you're on mute.
can you
Oh,
hear me now?
I hear you.
Okay. Can everybody hear me? I'm slow on hitting that unmute button. I apologize. Anyway, Mr. Jerkowitz, per the notice of oral argument, the parties have 5 minutes allocated each to make closing statements, and we'll start with Mr. Jerkowitz on behalf of petitioner.
Thank you. I don't think anything new was raised by Ms. Smith that I haven't addressed already, but it sort of enforces the entire argument being raised is the conduct was of such a severity or was so egregious that therefore there's nothing that Dr. Aho could have done to demonstrate that he is entitled to early termination of probation. And again, as I said before, that's a fallacy on both the factual level and on the legal level. But I do want to address some specific issues that Ms. Smith raised. First of all, she cited to some evaluations and examinations of Dr. Aho, in which she stated that the doctor evaluating Dr. Aho, and this is also in the brief, Drs. Katz and Dr. Markham Kristen opined that he's safe to practice if he's continued to be monitored. Do you want to know what year that was? Those evaluations were done in 2019. So the medical board is citing to evaluations stating that Dr. Aho needs to be continued compliance that were done in 2019. And for 3 years or so, he did all of those requirements without legal, without legally being mandated to do so by the board. He, essentially voluntarily engaged in those. So again, that argument makes sense if those evaluations were done and presented in evidence 6 months ago when we did the hearing. Then we'd have something to talk about. But we have no clinical evaluation of Dr. Aho being done anytime recently that says he needs to maintain his monitoring in order to be safe to practice. In fact, on the contrary, the evidence that we presented, our witnesses testify that based on their observations and knowledge of Dr. Aho and his sobriety and his programs, that he is safe to practice without restrictions. Ms. Smith also mentioned a number of things that Dr. Aho didn't do. She doesn't mention all the things he did do and highlights those, but coursework, apologizing to the patient, engaging in therapy, those are not requirements. And under the law, we have a rehabilitation, we have a statute that outlines what we look at for someone to be rehabilitated. That's not part of that analysis. And yes, if he had engaged in therapy or took coursework beyond what he was mandated to do, I suppose that would bolster his position and his petition, but it certainly wasn't necessary, and those aren't relevant factors for rehabilitation. Essentially, in layman's terms, you need to look at Dr. Aho today and say, is he a different person today than he was 7 years ago, such that he would not engage in the same conduct today that he did 7 years ago? And the answer to that is 100%. He is a different person today, and he would not engage in that conduct. And then the last point I want to make is Ms. Smith argues to don't prematurely terminate Dr. Aho's probation. Again, just to make sure we're all clear on the timeline, we've got close to 7 years or so of sobriety. We've also got 3.5 years of Dr. Aho being on probation. So this is unfair to characterize this termination of probation as premature in any way. There's a significant enough track record here for you to reasonably opine that he has rehabilitated, he's demonstrated that he's safe to practice and that he can continue to practice safely without any concern for the public. All right, thank you.
Slow on the hitting the unmute button. Everybody can hear me. I'm sorry if I'm slow on that. Okay. So Ms. Smith, closing statement.
Thank you, Your Honor. This misconduct is serious, and there is the potential of relapse by Dr. Aho. He is always at risk for relapse. And let's look at him today. Where is a medical evaluation stating that he is safe to practice without any restrictions? Where is a medical clearance stating that he has been evaluated and he is safe to practice without the careful restrictions that were put in place to protect the public while allow him to continue practicing neurosurgery? And also important is, where is the plan to handle the stressors of an increased workload? Dr. Aho has not provided any of those things, important things, at the time of his at the hearing of his petition for early termination of probation. And based on the evidence presented, it is not in the public's interest to permit petitioner to practice neurosurgery without probationary oversight and supervision of the board at this time. And I also would like to highlight Dr. O'Mahony, who testified on Dr. Aho's behalf. She testified that she does not know if he will continue in attending group meetings in the event of his early termination of probation. They are waiting to see if he gets his probation terminated, whether to talk about whether he wants to continue or not. This plan needs to be put in place before probation is terminated early. And in order to protect the public, a plan needs to be in place to prevent relapse. He has not done that. Continued board oversight will ensure that petitioner is practicing safely. He has not met his burden, and it would be contrary to public safety, health, and welfare to terminate his probation early. Thank you.
Okay, thank you. So with that, as we discussed earlier, the panel members are invited to ask questions of Dr. Aho. So with that, do any panel members have any questions?
Mr. Architect?
Thank you. And thank you, Dr. Aho, for coming. I realize this is not the easiest thing to sit through, but I have a lot of respect for you coming here in person. I wanted to ask about the 2024 suspension at Whittier Hospital. Apparently this took place on or about September, October 2024. Can you give me some detail about what happened?
Absolutely. So after I went to rehab and started my recovery process, PIH Hospital was very, very supportive of that for 3.5 years. And I did do all that, in a wellness program with PIH. Once I went on probation, the board of directors of the hospital hated that I was on probation, and they created some accusations of poor clinical care. I've participated in a hearing for that for about 15 months, and I just won the hearing. And there's a settlement that the hospital is doing with me for wrongful, but they would not renew my privileges, and that was, and there's a doctor's jury after a year, and they all unanimously voted that my care was above the standard of care and not an issue. So that's been resolved in my favor. And Mr. Jerkowitz has participated in that as well. Did that answer your question?
Yes, thank you. And I think it would be helpful if we could verify that, of course. But
Absolutely.
that does help resolve that question. Thank you, Doctor.
What I just said is all in writing.
Okay. Any other questions, Mr. Watson?
Yes, this is a question for Mr. Ahu's attorney first, and I'll have a question for Mr. Ahu himself. So my question is, we listened to the Deputy Attorney General stating that there is no independent evaluation, psychiatric and otherwise, all to establish what your current status are. So if there is no current evaluation, because you pointed out that is in 2019 and it is so far back, you also made a statement, well, that I'm holding you to, that this is the most complete, petition that you can present. Don't you think, and I'm asking you, that having that missing piece, that's evidence, not from people that are not a treating physician, would have helped in this scenario? Because that's a pretty big way to not just lay claim, but proof claim that Dr. Ahu is, in this new state. You say it, but if we don't have an independent evaluation of it, I don't see the evidence for that. And I'm just asking you, maybe there is. I've read this thing a million times. And I'm just curious what your response is to that.
Yes, thank you for that question. I have two responses. It's a good question. The first is we did have that. So Dr. Helen O. Mahoney, PhD, and this is in findings 19, she did testify. She's a licensed clinical psychologist for 15 years. She's the head of Flying Knee, which is the program that Dr. Aho is part of. And she presented a letter and evidence and testified that in her experience and her knowledge of Dr. Aho, working closely with him and monitoring him. I mean, she's not just an evaluator, one time seeing him. She's monitoring him in the program, and she testified that he's safe to practice. So there absolutely is evidence in the record of that. And I urge the board to look carefully both at the letters she presented and her actual testimony, which demonstrate unequivocally that in her evaluation as a clinical specialist, he's safe to practice. So that's first of all. The second point I would make is even if we didn't have that evidence, which we did, and I think that's conclusive right there and should give the panel more than enough confidence in terminating probation. But even if that evidence weren't there, I would argue that piece of evidence is not necessary. What's required is to establish that Dr. Aho is rehabilitated, and therefore that's the standard he needs to meet to be taken off probation. There's more than one way to skin a cat, as they say. So yes, presenting evidence like that could be one way in which you would establish that Dr. Aho is safe to practice, certainly. But there's other ways of establishing that evidence, and the standard under the regulations for rehabilitation does not require a new evaluation. And I would argue that such an evaluation isn't necessary at this stage anyways. He's on probation, he's being monitored. We want those evaluations, in my opinion, for someone brand new that we have no track record of. How do we know that this person is safe or not safe? You get an evaluation at that point, and that's why these were done in 2019 and before the board filed an accusation, because we have no track record. On the contrary, with Dr. Aho, we have an extensive track record. He's being monitored by you, right? He's being monitored by the medical board. You know that he's in compliance. You know that he's going to all his meetings. You know that he's doing all the things he needs to do. You know that he's testing negative. You have more than sufficient evidence, even without Dr. O'Mahony's testimony. But Dr. O'Mahony's testimony, in my opinion, just seals the deal with respect to that.
My second question, thank you for that.
May I add that Dr. O'Mahony only oversees group support therapy. She does not provide psychiatry. She does not provide any addiction, psychiatric care and treatment. And if you look at her testimony during the hearing, she also did not provide any individual therapy of petitioner. In addition, she did not provide a medical evaluation of petitioners, just to clarify. Thank you.
Yeah, so welcome, Dr. Al.
Thank you.
I'm just glad that you showed up. And my question is more about asking you that period from 2019 till the board actually filed an accusation and then presented you with a disciplinary stipulation. That period there, you probably had some realizations in that 3 years of that investigation. Because, and I want to ask you because you took some action from 2019 to 2020, whenever the board filed this. I want to just understand what triggered inside of you that said, I must do this. Because there's this 3-year period where you did individual work. Was that also compelled by, a physician oversight?
Well, so all the work that I did in the first 3.5 years before probation was voluntary. I didn't at that time require the board to tell me to do those things. I didn't know what the accusations were going to be or when. But most of all, I really truly was embarrassed and ashamed, and I can't believe that I actually had that issue with that patient, and that I wished I got help beforehand, and I didn't know how to. And regardless, if I wasn't in trouble with the medical board, I wanted help, and I didn't know where to go. And so once that situation transpired, I took the opportunity to, because I didn't want to. Historically, I was not in that position of using drugs and alcohol, and I wanted to be back sober, I guess, or not using it. And I really took everything I learned in rehab and the afterwards program to heart. And I think that's, I've been in 7 years with flying knee. I've seen a lot of doctors, and you're correct. Some people don't get sober till the board is there, but that's not my case. I think the first 3.5 years is a good example of how I'll be off of probation, but I didn't require probation to get 3.5 years sobriety. Does that answer your question?
Thank you. That was the first part of that question. Was it needed to be done? What's that? Closer. Okay. So it needed to be done. So there was an incentive and a real motivation because board probation has come. So here's my final question in that same category is basically the board stipulates this. Would you give us, was it helpful in your rehabilitation? Because the board put really solid guardrails on, and I want to just ask your objective opinion of whether it helped you to grow, whether it helped you to get a different insight.
You mean, did probation help me?
Yes, the actual stipulation that was stringent.
Well, it helped me atone for my sins, so to speak. Made me, really take ownership of it, and over the years think about it. However, there's lots of ways to recover. as the DA wants to say, some independent psychologist, I did do that voluntarily for a year. That's a long time. And psychotherapy helps some people and it doesn't, but I stayed with it for a year voluntarily. What helps me then and now is AA. And I'm a strong supporter of AA. I participate heavily. I work the steps. I think it's changed me as a person. It's largely proven in our society and studies that AA is what keeps people sober in the long run, not necessarily probation. I know lots of doctors in AA, caduceus AA, that 20, 30 years, and they're not on probation, and they're able to do it, and those are my role models. So I personally tried this psychologist, and AA is what kept me sober for the first 3.5 years. And I participate, and that's not a requirement of probation or the board, but it's what keeps me healthy. And so I'm not saying I shouldn't have been disciplined, because I should have, but in my recovery, it's AA that keeps me strong. It's not some restriction here. I can't work with PAs there. I mean, that doesn't really keep me sober. Hopefully I answer your question.
Any other questions, Miss Dr. Ala Rodriguez?
Thank you so much. And just like following up on that last comment, right now you're picturing some form of balance between the day-to-day work responsibilities with self-support. Is your intention in increasing hours, increasing workload? Do you have any plans on increasing self-support?
Well, that is the self-support. So I go to a minimum of 3 hours of A. So this idea that I don't have an aftercare program, all of a sudden the probation is keeping me sober, is a fallacy. I go to minimum, those are an hour a week, so that's 3 hours, and a lot of times I go to more.
And that's like for understanding, for example, is that like an open range? Is that more like, can you go more on demand? Like if you need, like, if you believe that you have to go more times?
Yeah, I mean, in AA, Southern California is one of the best places to be for AA. There's 20 meetings a day, so you go morning, afternoon, night. You can go as long as you make the time. I don't really see being off probation. It might open my opportunities. I mean, but that doesn't mean I want to necessarily work harder at this point. I mean, 53, not old, but I started when I was 33. I kind of like my work-life balance now. I like my family. I love my wife. I like to do things with them. I like to golf. I learned some of those things again being in recovery. So this idea that you're assuming or predicting that I'm going to, with more opportunity, all of a sudden torture myself and forget everything I learned, I think is false. Did I answer your question?
Yeah, so kind of in that same vein, if probation was terminated, what are the additional privileges that you would seek, and what is the additional workload you would undertake?
Yeah, so I reestablished practice in Lancaster, but I joined this Dr. Liker who testified at my hearing, and he's kind of our managing partner, and he has his practices in Henry Mayo Hospital in Santa Clarita. So it'd just be, I'd get privileges there and be able to help out call now and then with the group and participate with the group, because I'm kind of like, like the black sheep, so to speak, on the side, waiting to participate fully with the group. That doesn't mean that I'd take another 7 days of call, 7 days of call or something like that. It's just being able to get privileged to work with the current group I'm at and to help them out. But like Dr. Like is very understanding, and we train together at USC, and he's not trying to cause hardship on me either. So it's just, and I can't really get privileges now being on probation at Henry Mayo, so it would help out. But I don't foresee. I'm just telling you, I don't really want to work more than I am right now. And I moved to Lancaster. So I live in Lancaster now because I'm pursuing, while working with Dr. Laker, I'm pursuing Lancaster as kind of my hospital. So I would help them out, but I wouldn't be doing that much more.
Any other questions, Mr. Arkansas? Nope. Any other comments, concerns? Well, being last, they all stole my question. So I think that concludes our questioning from the board, Your Honor.
Okay, so with that, unless there's anything else, I'm going to close the record, and the panel will meet in short order in executive session and review the existing record, including the transcript of this matter, and the parties will receive the board's decision in due course. So I want to thank everyone for their participation, counsel and Dr. Aho and the panel members. So with that, the record is closed.
Thank you. Thank you to everyone.
Thank you.
Thank you.
Thank you, Counsel. Dr. Aho, thank you for showing up. And we're going to close this agenda item and move into closed session. Thank you, everyone.
Okay, thank you.
Thanks, Judge.
Thank you.
Go ahead and putting a slide up here for closed session. Judge, if you'll be joining us in the closed session, that session's open for you to join.
Yeah, so I'll be joining on the separate link for the closed session. So I'll just exit this.
Exit here, yes.
Right.
And I just sent you that information, so you'll have it top of your inbox.
Got it.
Thank you, Irene. We will talk again.
Yes. I have a few questions regarding spelling. Do you have an email that I could send an email to get that information?
Through Kennedy Corp, I could probably coordinate with our panel analysts. That would be the easiest way to get in touch with Sandra to get that information.
Okay. And then where can I find the panel analyst?
So I'm sorry, Ms. Lim, what spellings do you need? Because maybe that'll help everyone.
Oh, sure. I have a Dr. Kristen. Is that Kristen?
Let's see. I don't know who's.
I'm getting out in a second, okay? I just have to close this one before I get out.
Yeah, I think the analyst is probably the best one. I should have. I don't know if Ms. Smith's still there. She probably left the room.
They've already exited.
Yeah.
We can have our panel analyst reach out. We have your email, Irene, so we can have them get in direct contact with you.
Perfect. I greatly appreciate that. I can't submit the document without having contact information. So if I could get her or him to respond within the next day or two, that would be really appreciated.
Yeah, right after the closed session, we'll have them contact.
Okay. Thank you so much. Have a great day, everyone.
Thanks, Ms. Lim. Okay. All right. So I'm just going to transition here myself to the executive session and leave this webinar.
Thanks, Judge. See you there.
Can I leave now? Can I leave this one now?
Yes.
Okay.